All rise. Court of Appeals, Division 1 is now in session.
Good morning. Please be seated. This is the time set for oral argument in the matter of the Lloyd Revocable Trust, HAWORTH et al. Versus LIGON, I hope I'm pronouncing that correctly, et al. Our civil number 16-0458. Each side will have 20 minutes within which to present their arguments this morning. Appellants may reserve some portion of that for rebuttal. It's up to you to keep track of that, please, at the podium. We have read the briefs, been through the record, and are familiar with the underlying facts and issues that you've raised, and we've conferenced the case as well. We're recording this argument, both audio and by video, and the video will be available on YouTube within a matter of days after the argument's completed. As you approach the podium, I'd ask each of you to identify yourselves and your client for us, please. With that, appellant may proceed.
Thank you, Your Honor. Good morning, Judge Johnson, Judge Cluse, Judge Winthrop. My name's Thomas Dinker, and I represent Judy and Grover Ligon, the appellants in this action. And I would like to reserve about 5 minutes at the end of my time for rebuttal. If I may, I would like to start by addressing the issue that the court raised in its order of last week. And this is actually interesting because when it comes to the statute of limitation, there actually are two issues. There's the issue that the parties addressed in their brief, which is the question of when any tolling ceased. But the court has identified a separate issue, which is not addressed by the parties in their brief, and that is the question of when did the statute of limitation begin to run, irrespective of any tolling that there may have been. And so I'd like to start with the court's question. I'd like to start there. And allow me to say first that it would be an extraordinary interpretation of the statute. In fact, I would submit a irrational interpretation of the statute of limitation, which, after all, the title of this statute is Limitation of Action Against Trustee. To take that statute and give it an interpretation that actually would be an extension of the time for filing an action against the trustee to 2 years past a full and complete distribution of trust assets, in spite of and without giving any respect to the question of when the aggrieved beneficiary became aware that he had a claim of action. So, in fact, this would be, to my knowledge, such an interpretation would make this the only statute of limitation that by its own terms would compel an indefinite deferral of its own start date without regard to when the claimant became aware of his claim.
Well, when under your understanding of the facts of this case, were the beneficiaries' interests in the trust terminated?
At the time that they should have received their distribution.
What's but they didn't. So don't they still have a continuing interest in the trust?
No, Your Honor. And again, both because that would constitute an indefinite extension under the statute, that also, I submit, would effectively mean that there is no statute of limitation for a breach of trust for failure to make full and complete distribution. So long as the trustee is holding assets, then the statute would not begin to run. So you would never actually have a start date to the statute for breach of trust on the basis of failure to make a proper distribution.
Have you got a case for that proposition?
I don't. It's simply common sense, I would submit, Your Honor, that you wouldn't have any start. I do, however, have reference to another statute where the legislature has clearly contemplated that a trustee will still be in possession of distributable assets after a trust has terminated or partially terminated. If you look at ARS 14-10817B,
0817B?
10817B, yes, Your Honor. It specifically contemplates what the trustee will do with distributable assets after a trust terminates or partially terminates. And in particular, the trustee is supposed to distribute it. But the point is that there's nothing inconsistent or unusual about a trustee continuing to be in possession of trust assets after the trust terminates or partially terminates. So again, because we've got a situation where there would be no statute of limitation for improper distribution, and because it's consistent with the legislative scheme, I think it's clear that the statute started when they should have received their distribution. Now, another point on this is that if we said that a statute of limitation will be indefinitely postponed while the trustee is retaining distributable assets, that actually would be a violation of the rule against perpetuities. We would be saying that a trust interest would remain in trust indefinitely until the trustee factually distributes it. And so that would be not only a violation of the rule against perpetuities, but it would be inconsistent with ARS section 33-261, which is the statutory codification of the rule against perpetuities. So I think for that reason as well, it's clear that there can't be this perpetual indefinite deferral of the start date of the statute of limitation. Also, don't forget that this entire trust and all interests under the trust terminated when the youngest beneficiary attained the age of 25. And that was Autumn Haworth in August, I think it was August 21st, 2010. So it's not even a question of partial termination of the trust. The entire trust at that point was distributable. Also, I would point out one other factor just as a factual matter, and that is that the entire trust res dissipated and the trust, along with all interests under the trust, terminated when the trustee repudiated the trust and claimed all the assets for her own. And that is in the record it's page 141 of our brief. It's in the appendix, but under the numbering convention, it's page 141 of the brief. It's an email dated August 17th from Mrs. LIGON to Autumn Haworth, and it says, Autumn, let me make it clear that you have no inheritance from Ruth and Bob Lloyd. I inherited all of the assets. So again, we've got a repudiation of the trust, and that actually happened 4 days before Autumn's 25th birthday. So any way you look at this, I think that we have to say that the statute began to run in August of 2010. And finally, that's consistent with the Harris Trust case. The Harris Trust and its progeny, which was still being cited as recently as 2015 in the McDougall case, which says that a cause of action for breach of trust accrues when the trustee, by word or deed, repudiates the trust. And I think that we saw that here in August of 2010. And after all, that's consistent with the common sense traditional understanding that we all have that a cause of action accrues when the actionable conduct takes place. And again, that was August of 2015. So in answer to the court's question in terms of statutory interpretation, I believe it's clear that the statute would have, apart from tolling, would have started in August of 2010. And by the way, the McDougall versus McCarty case is not in our brief, but I do have a citation for it if the court is interested. It's really no different than Harris Trust, but it's a Lexis citation, 2015 U.S. District Lexis 189357. Now, there is another argument that was raised below. I'd like to address it as another part of addressing this question when the statute began to run. And the reason I'd like to address it is because I think the statutory interpretation is clear, as I just argued. But I don't want to ignore the fact that in the court below, the appellants made another argument, and that was an argument, and they did not make it in their brief, but I do want to address it for the sake of clarity for the court. In the lower court, they interpreted the statutory language on page 4 of the trust, which is page 44 of our appendix, or of our brief in the appendix, in which it describes the distribution order to the trustee with respect to the underage beneficiaries. And it says, upon such beneficiaries attaining the age of 25 years, comma, then their separate share trust shall be distributed to them, and the trust estate as to such beneficiaries shall thereupon terminate. They had made the argument, and I don't think it's a good argument, but I do want to address it, that somehow the trust language itself answers the question that the court was bringing up, when does the statute start to run? They say, well, until there's been a distribution under the language of the trust itself, there hasn't been a distribution. In this case, with respect to that argument, I think a correct reading of that language is that upon reaching the age 25 years, that the trust share of that beneficiary shall terminate, and the intervening language simply describes what happens to that beneficiary share at that time. I think this was written to account for exactly the situation that developed here, where we had a couple of underage beneficiaries, and this is just saying that when they reach age 25, they're no longer a beneficiary, they no longer have an interest in the trust, and they get their share. Again, this also is consistent with 14-10817B, which again recognizes that it is normal for a trustee still to be in possession of distributable trust assets after a trust terminates or partially terminates. The contrary interpretation would again would cause a violation of the rule against perpetuities. We're saying that the trust would continue so long as the trustee retains property irrespective of any other events. And again, I submit it would be irrational to give the trust an interpretation that would cause it to violate the rule against perpetuities. And then once again, as was the case with the statutory interpretation, we did have a repudiation of the trust in July of 2010. So the trustee, again, by act and by word and deed, repudiated the trust, claimed the assets for her own, certainly no later than August of 2010. And similarly, the whole trust was indeed to terminate in August of 2010 at Autumn's 25th birthday, so the interests under the trust would terminate at that time as well. So any way you look at this, I think it's quite clear that the statute of limitation, again, in the absence of any tolling, would have started to run, or did start to run, rather, no later than August 2010. Now, with respect to, well, let me make one final point on this. As I mentioned, the HAWORTH sisters did argue this point below. In fact, the parties argued the issue of when the statute began to run below. And the trial court impliedly rejected the HAWORTH's position that it started sometime later when it issued its September 2013 ruling, which hinged entirely upon the tolling issue. And so I would just point out to the court that this was not raised by the parties in the briefing, even though it had been litigated below. As far as tolling itself goes, I think the briefing is quite clear that the parties certainly had notice, or excuse me, the HAWORTH certainly had notice of all the facts that they needed in order to file suit no later than December of 2010, when Ms. Kulesh sent her letter that we reference extensively in our briefing.
But wouldn't that claim at that time be something like, well, I hear from family lore that there's a will or something that gives me some money, and I don't know how much it is, but I'm entitled to it?
It might be something like that, Your Honor, if I may, and there's nothing improper about that. In fact, that's often how cases are, particularly in these probate cases. Certainly, we litigate these all the time, and that may very well be enough. Certainly, if we had the kind of evidence that Ms. Kulesh clearly had about the existence of the trust, the assets that are in the trust, how they're titled, the fact that they're getting ready to be sold, and let's not forget that there's a reporting requirement, and 14-11001 says that any breach of a trustee's duty is a breach of trust, and that includes the reporting requirements under 14-10813. So they clearly knew in that letter that there had been a breach of trust. There had been a failure to report and a failure to provide the trust document. So I really don't think that you can get around it by saying family lore. That certainly the reporting requirements that Ms. Kulesh, as an attorney, certainly knew of, certainly isn't a matter of family lore. Also, if I may read to you from our current Rule 11B3, Civil Procedure Rule B3, it says that by signing a pleading, motion, or other document, the attorney or party certifies that to the best of the person's knowledge, information, and belief formed after reasonable inquiry, the factual contentions have evidentiary support or, if specifically so identified, will likely have evidentiary support after a reasonable opportunity for further investigation or discovery. So in other words, the rules clearly contemplate for the proper filing of a complaint under circumstances as maybe not as extreme as your example, where it was just family lore, but I understand the point. And I think that the answer is yes, that is proper under the rules. I would point out, in fairness, I am reading from the current Rule 11, but this language is consistent with prior case law interpreting the prior Rule 11. I would draw the Court's attention to a case called Hunter Construction Company. The citation is 190 Arizona 318, 190 318, in which the Court actually goes into some detail on page 322 and actually says that a lawyer does not even need to have yet assembled evidence sufficient to make a prima facie case before that lawyer files a case. So the HAWORTH simply cannot continue to make this argument that somehow they needed more facts than what they themselves set out in Attorney Kulesh's letter no later than December of 2010. With respect to the other issues that are raised in the brief, I would simply refer the court back to our briefing. I think the issues are clear with respect to the constructive trust and the attorney's fees award in this case, and reserve the rest of my time for rebuttal with the court's permission.
All right, counsel, thank you. Ms. Warner.
Good morning. May it please the court, I'm Katie Warner, and I am counsel for Autumn and Amber HAWORTH, who are the appellees in this matter and the petitioners in the underlying matter. This case raises the issue of whether a deceitful and dishonest trustee who breached her duties as trustee is going to be held accountable to her nieces, who she defrauded out of an inheritance, and whether my clients will be provided an adequate remedy to make them whole. The trustee breached her fiduciary duties. She failed to properly account for trust assets. She failed to provide any information as to where those assets, what those assets were and where those assets were located. She readily admits that she treated the trust assets as if they were her own. She commingled those with her personal property, and then she got married and commingled those with her husband's property. And For those reasons, it's our position that the Superior Court decision should stand. There's three things that need to be discussed today: the statute of limitations issue, the constructive trust issue, and the award of attorney's fees. As the court requested, we did take a look at the trust code, section 14-11005C2. So I'll start there. I disagree with appellant that the statute of limitations applies. Since the Haworth sisters never did receive any distribution, how could their interest in the trust terminate? There's a variety of ways that an interest in a trust can terminate. The trust could be revoked. That didn't happen here. The trust could be insolvent, meaning not enough to pay creditors, let alone distributions to beneficiaries. That's not the case here. The beneficiary could die, terminating their interest. That certainly didn't happen. There's a variety of ways that that could happen, and none of which occurred here.
Would you address the issue raised by Mr. Dinker about the rule against perpetuities and how its operation would prohibit us construing the statute to have the trust remain in place or no cause of action be available until distribution occurs?
Well, the rule against perpetuities is that an interest in a trust must terminate within 21 years of the lives in being. So in this instance, the lives in being are the named beneficiaries. That's Autumn, Amber, and Judy LIGON. And if the interest in the trust were to terminate without making distribution to any of those parties, then there would be no other recourse at law for them to obtain something that they were entitled to. I don't think that the statute is I don't think interpreting the statute to say that a beneficiary's trust or interest doesn't terminate until they receive everything that they're entitled to would violate the rule against perpetuities, because at some point all of the trust assets do need to be distributed, or the trust can't close and the trustee can't be discharged of her liabilities. And I think it's important to note that Arizona has adopted the Uniform Trust Code. There are slight variations in what we've adopted versus the Uniform Trust Code. With regard to this statute, the difference is a 5-year statute of limitations versus a 2-year. But I think the comment to the Uniform Trust Code is gives a lot of guidance in this matter. The comment states that subsection C is intended to provide some ultimate repose for actions against a trustee. However, the statute specifically does not address state law when it comes to, or overriding state law when it comes to issues of equitable tolling or fraud or misdeeds by the trustee. They specifically put that in the comment, stating that, yes, we're putting a limitation so that people can know when their rights are going to be terminated, but there's nothing to say that that can't be told by state law and equitable tolling as occurred here.
Well, Mr. Dinker was arguing that the letter or email in 2010 clearly constituted a repudiation of the trust, and that triggered the statute, irrespective of this other alleged bad behavior.
Well, the letter that he's referring to doesn't specifically say that she is terminating the trust or repudiating the trust. It simply states that my clients did not receive any inheritance from the decedent and that she received everything. I don't know that that's enough to be a repudiation of the trust that my clients didn't actually even know the terms of or true existence of. They didn't know if it was a trust or a will. They didn't know a lot of things. In fact, appellant relies heavily on this Kulash demand letter. However, from the terms of that letter, you can tell that they don't really know what's going on because they include a beneficiary who is not, in fact, a beneficiary. That would be the appellant's daughter, Nicole. She was not technically a beneficiary of the trust, yet she received funds from the trust. And so it's evident that my clients were relying on family information, not actual reliable information. And
before we move on to tolling, just to close the door on the running limitations issue, do other states interpreting the Uniform Trust Code give us any case authority on a weather limitations runs in a case like this where the trustee simply doesn't give the distribution? Is there
Not
any
that-
case you can draw attention to?
Not that I was
Okay.
able to locate.
Okay, thanks.
I would also like to point out that the reliance on the Kulash December 2010 letter is not appropriate because the appellant and her husband continued to deceive and lie after that letter was sent. They refused to respond to that letter and to the attorney, and instead Grover Ligon sent a letter in April of 2011 to Autumn Hayworth stating that Judy received everything from the trust, that my clients are entitled to nothing, and in fact, even in that letter, threatened any funds that Autumn Hayworth was going to receive as a gift from Judy if she did not drop her legal pursuit, then she was going to get nothing. She was entitled to nothing. Judy was being kind and going to give her something, and they're not going to give her something if they continue down this path. So they continued their deceit and manipulation to further their interests in keeping all of the assets of the trust.
What's the standard of review that we apply to a Superior Court ruling on tolling? Is that abuse of discretion?
Well, there was, I guess, a disagreement in that. I do believe that it is, if it's based on the application of facts to the law, then it is the abuse of discretion. If it's on whether the appropriate law was applied, I believe it's,
That'd be de novo, yeah.
yes, de novo. Thank you. It is our position that the court did not abuse their discretion and that that was the appropriate standard to apply. I would,
About constructive trust.
okay.
What do we know, specifically what I'm concerned about is, what do we know about the relationship between money that funds assets that once were in the trust and the acquisition of the new home? How much money went to buy the home, and what percentage of the home's price came from those assets?
It's my understanding that the full amount of the sale of the Sun City property was used to purchase the Tucson home, and I believe that the lower court found that amount to be $212,000 approximately, and that those funds fully were rolled into the Tucson property. I don't know the value of the Tucson property with regard to percentage of what that was for the down payment versus the value of the property at the time of purchase.
So it may be the case that the funds from the trust paid half the purchase price of the Tucson home.
Yes, and I am aware that there is a mortgage on the property.
Okay. Is there a case that says that a constructive trust is the proper remedy when in a situation like this where the plaintiffs have a interest in part of the value of the asset, but not the whole asset?
Well, the case law is, especially if you look at the case of Turley, they are, as many cases as there are addressing constructive trusts, there's as many different decisions on how they apply, and it's a very fact-intensive issue. One of the things with constructive trust is the ability to trace assets, and so through that tracing, you're supposed to be able to trace assets that were trust assets to where they now belong and recover those assets.
What happens now if we affirm the sisters have a constructive trust over the home? What happens now?
We send it to a collections attorney. They would pursue collection efforts, and whatever they can collect would, whether that's putting a lien on the home so that if it gets sold, then they would have a first right to obtain what they're entitled to. and depending on the value of the home and the value of the mortgage on the home, there may be also some things that they could do to force the sale of the home if it wouldn't bankrupt the appellants. And I would like to take an opportunity to point out that the Arizona Trust Code, statute 14-11001 provides a list of remedies that are available for a breach of trust, and that includes at subsection B9 that the court may impose a constructive trust on the trust property and trace the trust property wrongfully disposed of and recover the property or its proceeds. So this isn't just a common law recovery mechanism. This is statutorily allowed when it comes to breaches of trust. The appellants have argued that if there's other adequate remedies at law, that those are to supersede the constructive trust. They base that argument on the cases that have been cited, which are all civil litigated cases, not probate matters. And in the probate context, there isn't a case on point, but the statute is pretty clear that the trust can impose a constructive trust. It doesn't have to be another type of remedy before you do that.
I'm concerned about execution, say, of the sister's constructive trust interest on the home, given that it is a community asset, at least ostensibly a community asset. Without suing Grover, why is the trust entitled to? I'm sorry. Why are the sisters entitled to a remedy against his community interest in the home?
Well, as a recipient of property that didn't belong to him, I think that opens up his interest to being subject to the sister's interest. And the appellant has stated repeatedly that he didn't have an opportunity to defend, and that's just not true. He appeared as a party in the case. When we filed our motion to amend to include the claim for constructive trust remedy, Grover had counsel appear. It's documented in the court's record as early as the minute entry issued on December 2nd, 2015, where Mr. Canavan appeared on Grover's behalf. He didn't appear on Judy's behalf. He appeared on Grover's behalf. Judy was still pro per at that time. The minute entry on January 6, 2016, where the motion for reconsideration was denied, allowed us to file the amended motion for entry of final judgment to include this constructive trust issue. Mr. Canavan's office was provided a copy of the amended motion that was filed on January 15th, 2016. A separate copy was sent to Judy because she was still not represented by counsel at that time. And then on January 26, 2016, Mr. Canavan filed a notice of appearance on behalf of Judy so that he was then representing both Grover and Judy LIGON. On April 18, 2016, you'll notice that the final disclosure statement states that it is submitted on behalf of both respondents, Judy and Grover. And Grover appeared with counsel at the evidentiary hearing on May 5th, 2016.
But did the trial court have the occasion to actually ascertain whether Judy's husband, Grover, engaged in any wrongdoing?
No. At that point, the procedural posture of this case, liability had already been determined against Judy for the breach of trust. A constructive trust does not require that the party holding the property be liable for actions resulting in him obtaining the property. It just is that he's wrongfully holding the property.
How do we know that? What's the authority for that? Is that just something I should know? I
don't know that you should just know anything, but it's in the cases that we cited in our answering brief.
Okay.
And I'd like to point out that's 6 months of participating as a party, and not once did he raise the issue of improper service, improper joinder, any of those things. And by participating and not bringing an objection to his involvement, he waived those objections. he had plenty of opportunity to defend the issue of constructive trust and whether his property should be applied, and he chose not to. He participated in the hearings, and for all of our purposes, is subject to the judgment appropriately. The third issue when it comes to constructive trust is the trust res. And one of the things that a constructive trust is supposed to do is it takes effect at the time the wrongful act occurs, and it traces the funds gained by that act until rightful recovery is made. So over the course of this 5 years of litigation, Judy was unable to provide us with any conclusive accounting of the trust assets, what actually existed as trust assets, let alone where those assets ended up. It was only through our discovery and tracing that we were able to determine that those assets were commingled as into her personal property, and then when they were married, I think it was in 2011, commingled into the community assets. And there's no question that the house was commingled. I mean, there's deeds that are in the record that show the transfer from Judy to Grover. They even obtained a loan on the property jointly, and then sold it, and the proceeds used to purchase their Tucson home. Since a constructive trust is a statutory remedy for breach of trust, I think it is appropriate here. It's an available remedy, and it is an equitable remedy that will allow complete justice for Autumn and Amber. The third and final issue is the issue of attorney's fees. Appellant would have the court believe that under Civil Rule 54G that counsel was required to submit a fee affidavit, and we disagree. If you look at subsection 4 of that statute, at the end of it, it says that the provisions do not apply in causes in which the substantive law governing the action provides for recovery of such fees as an element of damages to be proved at trial. When we obtained the award of fees, there was no definitive judgment. The damages were to be proved at trial, and that's what we did.
But wasn't your proof simply an avowal as opposed to any documentary evidence or testimony from your clients?
That is true. The court did not require us to provide anything different. Under the rules of the probate procedure, Rule 33 governs the compensation of attorneys, and the court can require a fee affidavit to be filed. They certainly don't have to in all of the circumstances. The comment to Rule 33 specifically states that the rule does not apply when a party has requested that the court award the party fees against another party. And the comment further states that approval of attorney's fees is not required unless an interested person specifically requests that the court review the fees for reasonableness. The court found that the fees requested were reasonable based on, I'm sure, his experience in the probate court. $82,000 in fees over 5 years of litigation is certainly low.
Did Judy's lawyer not object during the hearing?
He did not specifically object. There was discussion, and it's in the transcript on like the last page about fees, and where the court, I believe it's the court that states that if the appellant would like to, they can require something to be filed, a fee affidavit to be filed so that they can review it for reasonableness. However, the court then made their ruling without requiring such a filing. And my time is up, so unless you have any other questions, I'm done.
Thank you, counsel.
I just wanted to address a couple of issues, the most critical of which relate again to the statute of limitation issue. In particular, counsel for the appellees had argued that it was appropriate to find, I guess, that tolling had restarted after the December 2010 letter from Attorney Kulesh. She didn't put it that way, but she said that tolling, continued tolling was appropriate because the appellants, the Ligons, and Grover Ligon in particular, continued to lie by sending an additional letter sometime in the spring, in April of 2011. But whatever Grover may have put into his letter in April of 2011, it did not cause the Haworths to forget what they already knew back in December of 2010, which was more than enough to file suit at that time. It certainly did not cause the Haworths to forget that Judy Ligon had not complied with her reporting obligations under 14-10813 and had not provided a copy of the trust instrument. So really, anything that happened from Grover's letter cannot possibly have induced reliance of the type that would prevent the Haworths from having filed suit long before the February of 2011, which was 2 years before the case was actually filed. Judge Johnson, you had asked a question whether we had a case for the proposition of when the statute would run, an affirmative case, and I had said, well, I think it's common sense. The better answer would have been no, and not only were we not able to find a case, in spite of desperately trying to after we got the court's order, thinking, okay, we're gonna do this, we couldn't, and we also couldn't find one from other states. It doesn't mean it wasn't there, but we couldn't find it. And so, unfortunately, I wish I had the home run case to back up what I think is a common sense interpretation of the statute, but I don't. A couple other issues in terms of insolvency of the trust. Judge Winthrop, I think, touched on this. The trust became insolvent when Judy Ligon repudiated it, and we also clearly do not have the elements of a constructive trust, which need to be both pled and proved by clear and convincing evidence. All of the elements need to be pled, in a pleading, and proven in order to establish a constructive trust, including a specific res currently in the hands of the party sought to be charged that you can trace to the breach of trust. And we certainly don't have that for Grover Ligon. Frankly, we don't have it for Judy Ligon as well.
Thank you, counsel.
Thank you.
Appreciate the arguments here this morning and for the briefing in this matter. We'll take this case under advisement and issue a decision in due course. We're going to take a short recess at this point to allow the parties for the next argument to come forward and get set up. Thank you.